Hi, myself Dr. Nagaratna, a faculty from the National Law School of India University, Bangalore. I will be now talking about negligent homicide and the possibility of imposing criminal liability under the Indian criminal law framework. Now, the possible section that would attract this particular offence is section 304A. Let us try to understand the extent of application of this provision, but before that let us go on with the understanding of the concept of mens rea that is involved in this offence, that is negligence and culpable homicide. Before that, it is for us to recollect that negligence is generally considered as both a tort as well as a crime, and criminalization of negligence, however, most often is limited to gross negligence conduct of the accused. Thus, most of the torts might not be criminalized, but what is criminalized might also be considered as a tort. Now, the Indian Penal Code criminalizes negligent acts resulting in injuries and also resulting in death. Negligence under criminal law is in fact treated as a form of mens rea. Negligent homicide is criminalized under all the criminal justice systems including Indian. The Indian law in fact makes a distinction between culpable homicide and negligent homicide. The courts have also determined various tests that needs to be applicable in order to determine the application of section 304A for an alleged offence of negligent homicide. In fact, there is a variation in the degree of culpability that is attached by the law to reckless homicide and negligent homicide and also culpable homicide. Though it is the same provision, that is section 304A, which applies both for reckless homicide as well as negligent homicide, there is a variation in the degree of liability that is attached for the two. Courts in fact will have to make an inquiry about the extent of mens rea that is involved and the nature of mens rea that is involved in a criminal conduct of an accused. That is, if an offence is committed due to recklessness, the liability is more in comparison to an offence that is committed under mere negligence. Hence, though it is the same provision, that is section 304A of Indian Penal Code, which deals with both, courts have considered the two as distinct while imposing punishment, thereby making reckless homicide a more serious offence than that of negligent homicide. Similarly, courts, while dealing with the cases of medical negligence, also have emphasized upon the difference that exists between mere negligence, which is generally considered as a wrong under civil law, and gross negligence which is criminalized under the criminal law. Now, the offence of negligent homicide in fact includes the deaths that are caused many times due to medical negligence or due to road accidents or due to any such other reckless or negligent conduct on the part of the accused. However, as these are the offences, though that leads to death, lack a specific intention and knowledge to cause the death of the victim, they cannot be categorized as culpable homicide. Being a case of negligently causing death or recklessly causing death, they are considered as a separate category of homicide dealt with in the name of negligent homicide. The offence of negligent homicide, therefore, is the one that falls under section 304A of the Indian Penal Code. As said earlier, road accident cases resulting in death, medical negligent cases resulting in death may all be some of the examples of the cases that may fall under this particular provision. Let us try to understand the conceptual difference that lies between the two terms, negligence and rash act. Under criminal law, negligence, recklessness, rashness are all in fact the terms that refers to varied forms of mens rea, which is in fact an important element of crime. Unless this is proved in a criminal case, a criminal liability cannot be attached. The term negligence implies omission to do something which a reasonable man, guided by those ordinary considerations which ordinarily regulates him or any other human affairs, would do, or doing of something which a reasonable and a prudent man would not do. Hence, negligence refers to doing something that he was not supposed to do or not doing something that he was supposed to do. Hence, it refers to failure to take reasonable care and caution. Negligence also includes doing of some act which a person of ordinary prudence would not have done under a similar situation, or failing to do something which a person of ordinary prudence would have done under that particular situation. Hence, negligence refers to both acts as well as omissions. The mens rea that is required to impose liability under section 304A of Indian Penal Code is either rashness or negligence. The term rash and negligence, though sound similar, yet they have difference under the law. Though both terms are interrelated, yet they are different forms of the same phenomenon, and both in fact refers to the acts that are done without intention. The court has clarified the distinction between these two terms in one of the most important case in India, that is Balachandra Vaman Party versus State of Maharashtra. The court, through the observation, says that rash act is the one which is a over hasty act done by an accused. It is something that is deliberately done by an accused in spite of knowing the fact that his act is riskier, he still takes up that risk. However, here he does not intend or does not know that he would be committing the crime. However, he has his knowledge of the risk that is associated with the task that is undertaking. That is, he knows that the act that which he is doing is riskier and can result in certain injury or even death, yet he, by foreseeing that risk, in fact oversees it and takes up that riskier act and ends up committing the offence of negligent or rash homicide. While on the other hand, negligence refers to breach of duty caused by omission to do something which a reasonable man would not do. It also refers to breach of the duty imposed by law, that is, the duty is the one which is imposed upon a person either by an express provision of law or by an implied provision of law. Negligence in fact refers to the acts that are done without consciousness that illegal mischievous effect will follow, yet under the circumstances which show that the actor had not exercised the caution incumbent upon him. On the other hand, culpable rashness refers to the acts that are done with consciousness that the mischievous and illegal consequence may follow, but with the hope that they will not. And the criminality in a rash act lies in running the risk of doing such an act with recklessness or indifference towards the consequence. Culpable rashness also includes hazarding a dangerous act or a wanton act with the knowledge that it is so and that it may cause injury, but without intention to cause injury or knowledge that it would probably cause. On the other hand, culpable negligence refers to gross and culpable neglect on the part of the accused or failure to exercise that reasonable and proper care and caution that any other reasonable man would have exercised in order to guard against the injury either to the public in general or to an individual victim in particular, which having regard to all the circumstances out of which the charge has arisen, it was the imperative duty of the accused person to have adopted. So, over here we see that there is failure to exercise due care and caution, or over here we see that there is breach of the duty that is imposed upon a person by the law. The criminality in this case lies in taking the care that, or in rather not taking the care that the law expects him to take. In R versus Lawrence and also in R versus Caldwell, it was clarified that recklessness on the part of the doer of an act does presuppose that there is something in the circumstance that would have drawn the attention of an ordinary prudent individual to the possibility that his act was capable of causing the kind of serious harmful consequence that the section which creates the offence was intended to prevent, and that the risk of those harmful consequences occurring was not so slight that an ordinary prudent individual would feel justified in treating them as negligible. It is only when this is so that the doer of the act is acting recklessly. If before doing the act, he either fails to give any thought to the possibility of there being any such risk, or having recognized that there was such risk, he nevertheless goes on to do it. In fact, this is the justification for imposing criminal liability for rash acts. Now, coming to the provision of the Indian Penal Code in relation to negligent homicide. It is section 304A, which deals with causing death by negligence. The wording of the section goes like this. It says, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide will be punished with imprisonment of either description for a term that can extend to 2 years, or with fine, or with both. Now, over here the provision refers to an act of causing death, however by negligence or by rashness, and this death caused under the section is the one which is done so without any intention or knowledge of causing such death. The actus reus required under the provision must indicate the presence of mens rea either in form of negligence or in form of rashness on the part of the accused. The provision applies only to such cases where there is neither intention nor knowledge of causing the death of the victim. Hence, the provision does not apply to a case where there is a clear intention to cause the death or where there is knowledge that the act can result in death. That is, the provision will not apply to the acts wherein a person voluntarily causes the death of the victim. Now, in Shankar Narayan case, the court indeed makes this clarification that intentionally causing death can never be a case that can fall under section 304A. So is also a case where a person voluntarily causes the death of the victim. Now, how do we determine the requisite mens rea of negligence? In order to determine the liability for negligent death and to apply section 304A, courts usually have applied the principle of reasonableness, almost similar to a case of tort. It is true that a law of negligence is founded on the reasonable conduct or reasonable care under all circumstances of a particular case. Hence, an accused will be liable for negligent death provided it is proved that he has failed to take reasonable care and caution expected to be taken by any reasonable man in a similar situation. However, it is important to note that the degree of negligence that is required under civil law and criminal law are different, though the test sounds to be similar. This principle of reasonableness indeed is also important in a case of criminal negligence, and that is the reason why it is said that the law of negligence is basically based on the reasonable conduct or the reasonable care under all circumstances of a particular case. Now, the 42nd report of the Law Commission of India, which was made available in the year 1971, in fact clarified the same by saying that the negligence mentioned in this section is not of the same type of civil disputes, and in civil cases the court insists upon maximum standard of care while criminal case requires minimum care. If minimum care is taken, then the criminal courts would acquit the accused. So, the standard of care that the report is referring to is the one that can result in exemption from liability under respective laws. In order to bring a clarity to the law, the Commission in its 1971 report further suggested for an alteration to section 304A by saying that an amendment to the section should be made to the effect that there should be addition of the words so as to indicate a want of due regard for human life. However, this recommendation so far has not found its place in the provision of the Indian Penal Code. Let us now see about the possibility of the application of section 304A. To fasten the liability in criminal law, the degree of negligence has to be higher than that which is required under a normal civil law where damages are claimed. The essential ingredient of mens rea cannot be excluded from consideration when the charge in the criminal court for criminal negligence is made. Further, the courts have repeatedly clarified that every slip or mistake is not capable of coming under this particular provision of criminal law. Thus, every slip or mistake is not culpable under criminal law. What needs is a clear proof of mens rea either in form of rashness or in form of recklessness or in form of negligence. rash and negligent act becomes punishable under section 304A, provided there is proof of rashness or negligence on the part of the accused, and not just that, there should also be a clear link between such rash and negligent act on the part of the accused and the death of the victim. Further to clarify, courts have repeatedly said that there must be an immediate cause of death, and that immediate cause of death should be the one which gets linked with the rash or the negligent conduct of the accused. Hence, the death should not be a remote cause of the negligent or the reckless act of the accused. That being one of the most important conditions for the application of section 304A, rather makes the provision very narrower in its application. Hence, 304A would only apply in a case where the death of the victim is shown as the direct result of the rash or the negligent act on the conduct of the accused. The negligent homicide, in order to be punishable under this provision, hence must be proved to be not just direct, but also the proximate result of the rash conduct of the accused or the negligent behavior of the accused. Death must be proved to be causa causans and not just causa sine qua non of the conduct of the accused. Similarly, courts further have clarified that a simple error in the judgment of a person need not be considered as negligence. There should be clear proof of mens rea in form of negligence or rashness on the part of the accused. This is more emphasized upon the cases of medical negligence, where courts have repeatedly said that error of decision on the part of the doctor solely shall not be a case that can bring an offence of causing death under this particular provision. Courts hence must consider the facts of each case subjectively and determine the requisite mens rea before applying section 304A. Negligence must be established by the prosecution or the complainant and can never be presumed by the court. Thus, a mere fact that the vehicle was driven fast or was going beyond the speed limit by itself or per se is not enough to result in an offence under this section. What needs to be proved is the guilt along with the proof of mens rea in form of negligence or rashness on the part of the accused and its causal link with the death of the victim. Unless these are proved beyond reasonable doubt, a case of conviction under this provision is not possible. We can see these clarifications also being made in reference to medical negligence cases, both in Suresh Gupta case as well as in Jacob Matthew case. The application of section 304A therefore will be suitable or will be applicable only in a case where you prove that there was no intention to cause the death or there was no knowledge that the act would in all probability result in death. Thus, this section will not apply for voluntarily causing death. It is also essential for us to understand that the general grounds of exceptions which is generally available under law of torts will not get extended to a case of crime, that is a case of criminal negligence. The contributory negligence, which in fact is one of the most commonly sought of defense in a law of tort, is not extended to criminal cases. Hence, unlike a case of tort, contributory negligence on the part of the victim cannot be a ground for defense for the accused in a criminal case. As long as the mens rea in the form of rashness or negligence is established by the prosecution, liability under section 304A is possible under IPC. Similarly, the principle of res ipsa loquitur, which means the thing itself speaks for, which generally applies in a case of tort or a civil matter, does not get extended to criminal case. Had this principle been extended, it would have reduced the burden on the part of the prosecution or the complainant. However, courts have repeatedly clarified that this provision is not subject to the application of this principle, or rather the principle of res ipsa loquitur does not get extended to a criminal negligence case. In a criminal negligence case, it is essential to establish again the mens rea in the form of rashness or negligence on the part of the accused along with the proof of actus reus on the part of the accused. So is also case under section 304A, not just limiting it to the cases of medical negligence resulting in death. Being a criminal case, the burden of proof is always upon the prosecution, including that of section 304A related cases. Hence, facts indicating negligence per se is not enough for conviction under criminal law, and the principle of res ipsa loquitur is not applicable in a case of 304A. Hence, proof of elements of crime is essential and mandatory under this provision. The primary reason for not applying this principle, as just briefed earlier, is because if the principle is applied, then the very basic principle of criminal justice system of the India will get affected, according to which the entire burden to prove the crime on the part of the accused or the guilt of the accused is upon the prosecution, and that cannot be compromised at any possible case. Now, while in a civil procedure, a mere preponderance of probability is something that is enough to result in finding the guilt of the parties or in imposing liability upon the parties, while that is not the case in a criminal matter. Presumption of guilt is something that always safeguards the interest of the accused, thereby imposing the burden upon the prosecution. In fact, it is these reasons which have made principle of res ipsa loquitur non-applicable for a case of crime, that is section 304A does not get subjected to the application of these provisions. Now, coming to the extent of liability that is imposed for deaths that are caused due to medical negligence. In the case of medical negligence, it is essential to establish that the culpable negligence on the part of the erring medical professional, and also bring the causal link between such medical negligence on the part of the medical professional and the death of the patient. Unless these two are proved, liability cannot be imposed. Further, such link must be immediate and direct consequence of the alleged medical negligence. Though medical negligence amounting to death can be covered under section 304A of Indian Penal Code, yet courts have impliedly applied a different method of determining the professional liability for negligence even for criminal cases. Courts in India have generally narrowed down the scope of application of section 304A for medical negligence cases. The Indian Supreme Court in Suresh Gupta case in fact held that to convict a doctor, the prosecution has to come out with a case of high degree of negligence on the part of the doctor. Mere lack of proper care or caution and attention or inadvertence might create civil liability, but not criminal one. The distinction between mere negligence and gross negligence on the part of the doctor was also clarified and made by the court in this case. The court clarified that for fixing criminal liability upon a doctor or a surgeon for medical negligence, the standard of negligence required to be proved should be higher than what is generally required under a civil case. It is not merely lack of necessary care, attention or skill that can make a case a criminal negligence case. The court further said that between civil and criminal liability of a doctor causing death of his patient, the court has a difficult task of weighing the degree of carelessness and negligence alleged on the part of the doctor. For conviction of a doctor for alleged criminal offence, the standard should be of that which is required for any other criminal cases, that is of beyond reasonable doubt. With specific reference to recklessness and negligence, the court says that it should be gross negligence and not mere negligence, which needs to be proved on the part of the accused. Coming to the next issue of road accidents resulting in death and the possibility of applying this particular provision. Though this section can apply for road accidents resulting in death, yet the courts have narrowed down the application of this provision by reiterating that there is a need to prove dementia in the form of negligence or recklessness or rashness, at least on the part of the accused. Now, according to the 234th report of the Legal Reforms to Combat Road Accidents published in the year 2009, it says that more than 1 lakh Indians die every year in road accidents and more than millions of them are injured or maimed. The same report also says that driving recklessly or dangerously and not observing traffic rules, or like crossing the speed limit, jumping red light, driving without driving license, driving by untrained or disqualified drivers, driving by minor, driving under the influence of liquor, driving while talking on the mobile phones, driving without helmets, ill health of the vehicle and bad road infrastructure are some of the common causes for road accidents. This report in fact lays emphasis upon negligence being one of the cause for these kind of deaths that are taking place on roads every day. And thus most of the road accidents thereby fall under the purview of section 304A of Indian Penal Code. Let us see the extent of liability that the provision applies for criminal negligence. The liability that section 304A applies for rash and negligent death is imprisonment of either description, that is rigorous or simple, for a term that can extend to 2 years or with fine or with both. Hence, it is possible that under section 304A for negligently or rashly causing death, an accused only gets imposed with fine, or it can be a case where he is subjected to imprisonment for a term that can extend up to 2 years and not more than 2 years, or it can be a case wherein he can be subjected to both fine as well as liability in form of imprisonment. It is essential to note that the maximum extent of imprisonment that can be imposed is only 2 years for causing death negligently or rashlessly. There are a lot of critiques and criticisms about this extent of punishment that the section provides for. Hence, the maximum punishment which just gets extended to 2 years has come under serious criticism by many academicians. Even the 42nd report of the Law Commission of India, published in 1971, also opined the same. It says that the present maximum punishment for the offence is inadequate and should be increased. This is desirable in view of the greater importance which this offence has assumed since the section was inserted due to the wide usage of fast moving mechanically propelled vehicles and the frequency in the commission of the offence, accompanied by callousness on the part of the offender towards the victim. Often there are cases tried under this section which are very near to culpable homicide and deserve severe punishment or sentence. The Commission further said that after taking into account our proposal to fix the maximum punishment for culpable homicide not amounting to murder at 10 years, we recommend that the minimum punishment for causing death by negligence may be half of that period, that is 5 years. Now, the Law Commission's 234th report on legal reforms to combat road accidents of 2009 said that the liability under section 304A is inappropriate and recommended for an increase of the same. It said that section 304A must be amended with an increase in the liability for the offence of rash and negligence with imprisonment extending up to 10 years instead of 2 years as is currently provided. It further said that causing death of any person through driving under the influence of drink or drugs should be punishable with a minimum term of imprisonment of 2 years. Similar view was also expressed by the Supreme Court in a recent case decided in the year 2012, that is Alistair Anthony Pereira versus State of Maharashtra. In this case, the court also refers to the WHO reports and other similar reports available on road accidents. It says that the World Health Organization in the Global Status Report on Road Safety has pointed out that speeding and drunk driving are the major contributing factors in road accidents. According to the National Crime Record Bureau of India, the total number of deaths due to road accidents in India every year is now over 1,35,000. The NCRB report also states that drunken driving is the major factor for road accidents. It further says that our country has a dubious distinction of registering maximum number of deaths in road accidents. It is high time that the lawmakers revisit the sentencing policy reflected in section 304A. Thus, an increase in the extent and the nature of punishment for negligent and rash conduct resulting in death is something that is considered as the need of the day by not just law commissions, but also by the apex court of the country. because often it is felt that the current extent of punishment provided by the provision is disproportionate to the in comparison to the nature of offence that the section talks about. Let us now summarize the module. The summary of the module is that negligent homicide, unlike culpable homicide, is imposed with lesser liability under the Indian Penal Code. It is section 304A of the Indian Penal Code which deals with negligent homicide. The section also talks about rash conduct on the part of the accused. Theoretically, mens rea in form of negligence, recklessness, rashness are all different. The courts have also accepted the same. In fact, the difference between these have always been considered by the court while imposing the extent of punishment. However, it is this one section which commonly applies for both negligence as well as rashness resulting in death, and that is section 304A. Though the provision is common, extent of liability has always been different depending upon the kind of mens rea that is proved in a case. It is important to note that the provision only gives punishment of imprisonment up to 2 years with or without fine, and this has often come under serious criticism, including the recent decision of Anthony Pereira's case makes it important for us to relook at the section, especially from the perspective of the extent of liability that the section attaches for causing death, though it is because of negligence or the rashness on the part of the accused. It is also important to note that though section 304A to an extent is wider in its application, becomes narrower if it is a case of medical negligence because of few safeguards that the courts have conferred upon the medical professionals through its decisions starting from Dr. Suresh Gupta case and Dr. Jacob Matthew case. It is also important to note that it is possible to bring road accidents resulting in death under this provision. Lastly, there is degree of variation in the extent of proof of the negligence on the part of the accused under civil law as well as under criminal law. Yet, the kind of test that is applied under both the laws are similar, and that is the test of a reasonable man. However, what varies is the nature of punishment that is imposed under both. While under one, a person could be criminally held liable, and under tort, negligence becomes the ground for claiming damages. And this is the law framework in relation to criminal liability that can be imposed for causing death due to negligence or rashness, that is for culpable homicide. Thank you.